latitude to depart is even greater where, as here, the petition in the High Court proceeded by way of affidavit evidence, and the court below did not have the added advantage of hearing and seeing the live witnesses in testimony. The first broad ground of appeal is that the High Court did not have jurisdiction to entertain the petition before it. The gist of the appellant's argument is that the issue before the High Court was a dispute relating to elections to the office of President, and therefore, by dint of Article 163(3)(a) of the Constitution, exclusively reserves the matter for determination by the Supreme Court, and further, Article 165(a) expressly prohibits the High Court from exercising jurisdiction over matters reserved for the exclusive jurisdiction of the High Court. While conceding that the dispute before the High Court did not involve a challenge of the election of a president-elect, the appellant nevertheless contended on the authority of the judgment of the Supreme Court in the matter of the principle of gender representation in the National Assembly and the Senate, that the exclusive jurisdiction of the Supreme Court is not limited to disputes that arise after the conclusion of the presidential election, but extends to disputes that may arise before and during the conduct of the presidential election. To the extent that the High Court declared the statutory provisions and regulations that were impugned before it unconstitutional, the appellant contended that the effect was to alter the process of declaration of results in a presidential election, which has a direct bearing on the conduct of a presidential election. Accordingly, in the appellant's view, the matter was exclusively reserved for the Supreme Court, and the High Court erred by assuming jurisdiction over it. A corollary challenge is that the High Court assumed jurisdiction over the petition because it erroneously assumed that the process leading to the election of the President had not commenced. In this submission, the appellant contended that the High Court appreciated that the dispute was reserved by the Constitution exclusively for the Supreme Court, but erroneously assumed jurisdiction on the basis that the process of the election of the President had not commenced. The appellant submitted that, contrary to the conclusion by the High Court, the appellant's chairperson had on 17th March 2017 published Gazette Notice number 2692, setting in motion the process of election of the President to be held on 8th August 2017. The appellant urged us to find that the High Court properly apprehended the factual situation. Had the High Court properly apprehended the factual situation, it could not have assumed jurisdiction. The position of all respondents, save for the fourth respondent who, as we have noted, did not address the issue raised by the appellant on jurisdiction and res judicata, is that the High Court did not err by assuming jurisdiction over the petition. They submitted that the issue raised in the petition was whether the impugned provisions of the Act and the regulations made thereunder were inconsistent with the Constitution. To that extent, the respondents contended that the High Court had jurisdiction by dint of Article 165(3)(d)(1) and 2, which empowered it to hear and determine any question whether any law is inconsistent with or in contravention of the Constitution, or whether anything said to be done under the authority of the Constitution or of any law is inconsistent with or in contravention of the Constitution. In their view, the petition before the High Court did not challenge the election of a presidential elect as contemplated by Article 140 of the Constitution, and therefore there was no basis for the submission by the appellant that the matter was exclusively reserved for the Supreme Court. The amicus added that even if there were if it were taken that the Supreme Court had jurisdiction over the matter, it was a shared jurisdiction with the High Court, and the judicial precedents demanded that the petition be heard and determined first by the High Court. It also disputed the appellant's assertion that the High Court assumed jurisdiction on the basis that the process for the election of the President had not commenced. In its view, that was not the basis upon which the High Court assumed jurisdiction. Lastly, the amicus invited us to find that the High Court had jurisdiction when the petition was filed in May 2016, that the jurisdiction was engaged as of that date, and that it could not be taken away by the subsequent commencement of the process for the election of the President. We would agree with the appellant that the conclusion of the High Court on the jurisdiction is somewhat contradictory. The court first found that the petition did not involve a dispute relating to the election of the office of the President within the meaning of Article 140. This is how the court expressed itself, and I quote, "This court takes judicial notice of the fact that the date of the next general election is 8th August 2017, and therefore a petition to challenge the presidential election can only be filed after the declaration of results following that general election," close quotes. The court also found that the petition before it did not raise other issues connected with the election for the office of the President, as would entitle the Supreme Court to assume jurisdiction under Rule 12.1 of the Supreme Court Presidential Election Petition Rules. The court identified those issues as the validity of the presidential election, declaration of a runoff, qualification of a president-elect, commission of an election offense, or validity of the nomination of a presidential candidate. The court concluded thus, and I quote, "This court takes the view that the instant petition does not relate to any of the grounds in Rule 12.2 of the Supreme Court Presidential Election Petition Rules. More specifically, the pleadings in the petition do not raise a question as to the validity of the presidential election, a declaration by the Commission under Article 138.5, the validity of the qualification of a presidential elect, the commission of an election offense as provided under Part 6 of the Election Act, or the validity of the nomination of a presidential election," close quotes. Later in the judgment, the court veered from the position it had taken that the dispute before it did not relate to the elections of the office of the President, and stated, and I quote, "In the instant case, the process of electing the President has not commenced. To our mind, a presidential election is activated when under Section 14 of the Elections Act, the Commission publishes a notice of holding of the elections in a gazette and in electronic and print media," close quote. This begs the question whether, had the court found that the process of electing the President had commenced, as the appellant submitted it had, would the court have concluded that it had no jurisdiction to entertain the petition? In our view, having concluded that the petition did not involve a dispute relating to the election to the office of President, and having found that it did not involve any of the matters set out in Rule 12.2, over which the Supreme Court has exclusive jurisdiction, the plunge into the question whether the process of electing the President had commenced added nothing to the judgment but sheer confusion. It gives the impression, as the appellant correctly submitted, that had the court found that the process of electing the President had commenced, it would not have assumed jurisdiction, which is really not in sync with its first conclusion, that the dispute did not involve election of the President or any other issue under Rule 12.2.
that lack of clarity notwithstanding, we are not hamstrung from determining the issues on its merit. The gist of the first, second, and third respondents' complaint was laid out in paragraph 4 of the petition, which reads as follows. Quote, the petitioners bring this suit as a matter of public interest, seeking relief for the declaratory orders, regulations 83(2) and 84 of the election general regulation are in contravention of the provisions of Articles 86B, C, and 138(2) of the Constitution of Kenya 2010, under the Act of the first respondent appointing its chairperson to the returning officer for presidential elections is contrary to the provisions of Articles 86B, C, and 138(2) of the Constitution of Kenya 2010. Prior to that, the said respondents had succinctly identified in the petition the jurisdiction of the High Court that they were invoking in the following terms. Quote, the petitioners bring this suit under Article 165(2)(d) of the Constitution, which grants this honorable court the jurisdiction to hear any question respecting the interpretation of the Constitution, including the determination of 1, the question whether any law is inconsistent with or in contravention of the Constitution, and 2, the question whether anything said to be done under the authority of the Constitution or any other law is inconsistent with or in contravention of the Constitution. End of quote. Paragraphs 37 to 41 of the petition set out in detail the manner in which the impugned regulations and Section 39, 1, 2, and 3 of the Elections Act 2011 are, in the said respondents' view, inconsistent with the Constitution. They concluded by praying for the 7 reliefs, which we have already set out in this judgment, whose cracks were declarations that the impugned provisions of the Act and of the regulations were inconsistent with the Constitution and therefore null and void. From the foregoing, we have no doubt in our minds that the first, second, and third respondents' petition was first and foremost seeking determination by the High Court of whether the specified provisions of the Elections Act 2011 and the regulations made thereunder were inconsistent with or in contravention of the Constitution. The other prayers were consequential upon the court finding that the impugned provisions and regulations were indeed inconsistent with or in contravention of the Constitution. Does the High Court have jurisdiction under the Constitution to entertain such a petition? In our view, the answer is in the affirmative and lies squarely in Article 165(3)(d) of the Constitution, which provides as follows. 3. Subject to Clause 5, the High Court shall have D. Jurisdiction to hear any question respecting the interpretation of this Constitution, including determination of 1. The question whether any law is inconsistent with or in contravention of this Constitution. 2. The question whether anything said to be done under the authority of this Constitution or any law is inconsistent with or in contravention of this Constitution. End of quote. Clause 5, to which this provision is subject, stipulates that the High Court shall not have jurisdiction in respect of matters reserved for the exclusive jurisdiction of the Supreme Court and those falling within the jurisdiction of the Employment and Labor Relations Court and the Environment and Land Court. The question placed before this court is whether the High Court determined issues that are exclusively reserved for the Supreme Court. Article 140 of the Constitution provides as follows on the jurisdiction of the Supreme Court regarding disputes as to validity of a presidential election. End of quote. Start of quote. 1. A person may file a petition in the Supreme Court to challenge the election of the president-elect within 7 days after the date of the declaration of the results of the presidential election. 2. Within 14 days after the filing of a petition under Clause 1, the Supreme Court shall hear and determine the petition, and its decision shall be final. 3. If the Supreme Court determines the election of the president-elect to be invalid, a fresh election shall be held within 60 days after the determination. End of quote. While a plain reading of the above provision leaves no doubt that the jurisdiction reserved exclusively for the Supreme Court is the determination of whether the president-elect has been validly elected, as happened in Raila Odinga and 2 others versus IBC and 3 others, the Supreme Court has stated that a dispute relating to the election of the office of president may arise even before the president-elect is declared pursuant to Article 138, sub-Article 10. In its advisory opinion in the matter of the principle of gender representation in the National Assembly and the Senate, the Supreme Court noted that a dispute regarding the election of a president can arise in scenarios other than what is contemplated in Article 140. These will include a situation where there is no president-elect, as in the case where no candidate is declared to have been duly elected under Article 138, sub-Article 4, or where there is a dispute arising in the process of ascertaining the 2 candidates with the most votes for the purposes of a runoff. The court concluded thus, and we quote them: "It is clear to us in unanimity that there are potential disputes from presidential elections other than those expressly mentioned in Article 140 of the Constitution. A presidential election, much like other elected assembly elections, is not lodged in a single event. It is, in effect, a process set in a plurality of stages. Article 137 of the Constitution provides for quote, qualifications and disqualifications for election as president, end of quote, and this touches on the tasks of agencies such as political parties, which deal with early stages of nomination. It touches also on election management by the Independent Electoral and Boundaries Commission, IBC. Therefore, outside the framework of the events of the day of presidential elections, there may well be contested questions falling within the terms of the statute of elections or of political parties. Yet still, the dispute would still have clear bearing on the conduct of the presidential election. 101. Does the entire question concerning presidential elections belong to the Supreme Court's jurisdiction, or is the Supreme Court's power limited by the express language of Article 140 of the Constitution? Besides, a reading of Article 87.2 alongside Article 163.3 suggests, as we perceive it, that the Supreme Court was intended to adjudicate upon all such disputes as would arise from the presidential election. We find no reason to presume that the framers of the Constitution intended that the Supreme Court should exercise original jurisdiction only in respect of a specific event, namely disputes arising after the election, while excluding those disputes which might arise during the conduct of elections, end of quote. We respect the opinion of the Supreme Court that there will be disputes relating to the elections to the office of president that arise even before the election of the president-elect has been announced. The Supreme Court Rules 2013, and in particular Rule 12, set out some of the issues that may arise outside the strict confines of Article 140 of the Constitution, such as the validity of the nomination of a presidential candidate or commission of an election offense by such candidate. What, in our view, is engaged in this appeal is the relationship between the exclusive jurisdiction of the Supreme Court and the jurisdiction of the High Court to interpret the Constitution. There is precedent from the Supreme Court stating that the fact that a matter is reserved for the Supreme Court does not take away the jurisdiction of the High Court to interpret the Constitution, and in appropriate cases, the Supreme Court will not consider the issue on first instance, but will consider the same in the context of its appellate jurisdiction. In the matter of the Interim Independent Electoral Commission, the petitioner sought an advisory opinion of the Supreme Court as to the date of the first general election under the Constitution of Kenya 2010. Under Article 163, Sub-Article 6 of the Constitution, the jurisdiction to give advisory opinions on any matter concerning county governments is vested exclusively in the Supreme Court. The Supreme Court found that the petition before it had properly engaged its exclusive jurisdiction to give advisory opinion. This is how the court expressed itself on the issue, and we quote it. Now, on the facts of the instant case, we would hold that election date is a question so central to county governments as to lie within the jurisdiction of this court in relation to the request for an advisory opinion, close quote. Even after finding that the issue before it was properly within its exclusive jurisdiction to render an advisory opinion, the Supreme Court did not take the view that the jurisdiction of the High Court to interpret the Constitution as regards the date of the first general election was ousted. The court found that the dispute before it also involved interpretation of the Constitution, which by dint of Article 165, Sub-Article 4, is vested in the High Court. The court was of the firm view that where litigation entails issues of constitutional interpretation, the matter must come in the first instance before the High Court, with the effect that interpretation of the Constitution by both the Court of Appeal and the Supreme Court will have been limited to the appellate stages. It bears to quote in full the court's conclusion. Quote, in this instance, similar questions entailing constitutional interpretation have been brought simultaneously before the High Court and the Supreme Court, and, as already noted, such a move by parties is apt to precipitate contretemps in resolving the question of jurisdiction. In principle, the Supreme Court commits itself to order and efficacy in the administration of justice, and to that end, it may require that the process of litigation commenced in the High Court and entailing constitutional interpretation be exhausted and, if need be, followed by appellate procedures. In such circumstances, this court will be cautious in considering a request for an opinion to ensure the two jurisdictions do not come into conflict, and each case will be carefully considered on its merits. Although the applicant in this instance avowedly seeks an advisory opinion, the application amounts to a request for an interpretation of Article 101, Sub-Article 1, 136, Sub-Article 2A, 177, Sub-Article 1A, and 180, Sub-Article 1 of the Constitution, and Clause 9 of the 6th Schedule to the Constitution. As the applicant apprehends conflict in the said provisions, it is to be taken to be seeking the correct interpretation of the said provisions. It is not seeking a plain opinion statement on the date of the next election. We find, therefore, that the question placed before us is not a normal one within the advisory opinion jurisdiction as envisaged under Article 163, Sub-Article 6 of the Constitution. The application is still more inappropriate in the light of the several petitions pending before the High Court. The two cases seek the interpretation of the Constitution with the object of determining the date of the next elections. Those petitions raise substantive issues that require a full hearing of the parties, and those matters are properly lodged, and the parties involved have filed their pleadings and made claims to be resolved by the High Court. To allow the application now before us would constitute an interference with due process and with the rights of parties to be heard before the court duly vested with jurisdiction. Allowing such an application would also constitute an impediment to the prospect of any appeal from the High Court up to the Supreme Court. This is a situation in which this court must protect the jurisdiction entrusted to the High Court. End of quote. Ultimately, the Supreme Court declined to exercise its exclusive jurisdiction, which it found properly engaged, and allowed the High Court to first exercise its jurisdiction to interpret the Constitution and the matter in the event of any party being dissatisfied by the decision of the High Court to end up before the Supreme Court through the appellate process. In view of the foregoing, we conclude that the High Court had jurisdiction to determine the constitutionality of the impugned provisions of the Elections Act and the regulations made thereunder, and the fact that the first, second, and third respondents could arguably have raised the issues before the Supreme Court under its rules did not deprive the High Court of the jurisdiction vested by Article 163, Sub-Article 3D. Accordingly, we are not persuaded that the High Court committed an error or assumed a jurisdiction that it did not have. Turning now to the second broad ground of appeal, namely res judicata. The appellant criticizes the learned judges as having, quote, erred in law and fact in holding that the matters before them did not run afoul of the doctrine of res judicata, end of quote. We have perused the record and note that the issue first arose in the appellant's replying affidavit in opposition to the petition before the High Court. In its first formulation of res judicata as an issue for the High Court's determination, the appellant submitted that the issues that the first, second, and third respondents intended to converse, quote, if looked at properly, end of quote, touched on the 2013 Kenya general election, and that to determine them would be akin to the High Court reopening Raila Odinga and 2 others versus IEBC and 3 others. It submitted further that, quote, the question posed by the first, second, and third respondents on who is the principal returning officer for purposes of presidential election results was answered and or should have been rightly posed, end of quote, in that case. It contended that the issue of tallying in the presidential election was considered in Africa Center for Open Governance, AFRICOG, versus Ahmed Isaac Hassan and another. It contended that the petition was an attempt to bring the same cause of action as previously decided by the Supreme Court, albeit with, quote, a few cosmetic changes, end of quote. The learned judges grappled with the subject, which they styled the second preliminary issue, at some length before arriving at this conclusion, which we quote. It is clear to us that the Supreme Court was not called upon to consider Section 39, subsection 2 and 3 of the Election Act. The court was not called upon to consider regulations 83.2, 84.1, or 87.2 of the Elections General Regulations of the Elections Act. the constitutionality of these provisions was not an issue, and neither was the court called upon to determine that. In our view, the Raila Odinga petition was a time-bound petition brought under Article 140 of the Constitution and which was to be determined within 14 days. It dealt with a straightforward question whether the president had been validly elected. It cannot be reasonably argued that the constitutionality of the impugned provisions ought to have been raised in the Raila Odinga petition. In our considered view, such a challenge could only be done before the High Court, as has presently been done, so that the parties can have, at the first instance, the court's interpretation of the matter before the parties can benefit from further interpretation on appeal up to the Supreme Court. There was allegation that the present petitioners were related to Gladwell Wadhoni Otieno and Zahin Rajan, who were some of the petitioners in the Raila Odinga petition. This claim, however, was not substantiated, and neither was it enthusiastically pursued. To conclude on this point, it is clear that the issues raised in the instant petition cannot, by any stretch of the imagination, be deemed to be the same as the ones that the Supreme Court dealt with in the Raila Odinga petition. We, therefore, find and hold that the present petition is not res judicata, end of quote. That finding has caused the appellant grief, as expressed in its ground of appeal under consideration. Is the grief justified? We think not. Res judicata is a matter properly to be addressed in limine, as it does possess jurisdictional consequence, because it constitutes a statutory peremptory preclusion of a certain category of suits. That much is clear from Section 7 of the Civil Procedure Act 2010, which we quote: "No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim, litigating under the same title in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court," end of quote. Thus, for the bar of res judicata to be effectively raised and upheld on account of a former suit, the following elements must all be satisfied, as they are rendered not in disjunctive but conjunctive terms. A, the suit or issue was directly and substantially in issue in the former suit. B, the former suit was between the same parties or parties under whom they or any of them claim. C, those parties were litigating under the same title. D, the issue was heard and finally determined in the former suit. And E, the court that formally heard and determined the issue was competent to try the subsequent suit or the suit in which the issue is raised. The learned judges were fully aware and applied their minds to these elements, applying this court's decision in Uhuru Highway Developers Limited versus Central Bank of Kenya. They rendered the elements as: A, the former judgment or order must be final. B, the judgment or order must be on merits. C, it must have been rendered by a court having jurisdiction over the subject matter and the parties. And D, there must be, between the first and the second action, identity of parties, of subject matter, and of cause of action, end of quote. The rule or doctrine of res judicata serves the salutary aim of bringing finality to litigation and affords parties closure and respite from the specter of being vexed, haunted, and hounded by issues and suits that have already been determined by a competent court. It is designed as a pragmatic and commonsensical protection against wastage of time and resources in an endless round of litigation at the behest of intrepid pleaders, hoping by a multiplicity of suits and fora to obtain at last outcomes favorable to themselves. Without it, there would be no end to litigation, and the judicial process would be rendered a noisome nuisance and brought to disrepute and calumny. The foundations of res judicata thus rest in the public interest for swift, sure, and certain justice. There is no dearth of learning or authority surrounding this issue, and this court has expressed itself on it endless times. In one recent decision, William Koros versus Hezekiah, Kiptor Komen, and 4 others, it was stated, and we quote, "The philosophy behind the principle of res judicata is that there has to be finality. Litigation must come to an end. It is a rule to counter the all too human propensity to keep trying until something gives. It is meant to provide rest and closure, for endless litigation and agitation does little more than vex and add to costs. A successful litigant must reap the fruits of his success, and the unsuccessful one must learn to let go." Speaking for the bench on the principles that underlie res judicata, Justice Y.V. Chandrachud, in the Indian Supreme Court case of Lal Chand versus Radha Kishan, stated, and we agree, quote, "The principle of res judicata is conceived in the larger public interest, which requires that all litigation must sooner than later come to an end. The principle is also founded in equity, justice, and good conscience, which require that a party which has once succeeded on an issue should not be permitted to be harassed by a multiplicity of proceedings involving determination of the same issue," end of quote. The practical effect of the res judicata doctrine is that it is a complete estoppel against any suit that runs afoul of it. And there's no way of going around it, not even by consent of the parties, because it is the court itself that is debarred by a jurisdictional injunct from entertaining such suit. That much was stated by this court in Gogi versus Kinyanjui and 3 others, when it was held that, quote, Section 7 was a mandatory bar from any fresh trial of a concluded issue, and a judge cannot competently get round that bar by obtaining the consent of the parties to an arbitration of a concluded issue, end of quote. The simple question before us then is whether the learned judges erred in their categorical finding that the petition before them was not res judicata, and the answer to the question is a straight no. We have already noted that the appellant in its written submissions did not locate its res judicata objection within the 4 or 5 Section 7 of the Civil Procedure Act elements that constitute it. Indeed, its submission at paragraph 88 was that, quote, "The issues that were raised in the High Court were directly related to the issues that were properly before the Supreme Court in Raila Odinga and 2 others versus IBC and 3 others. With respect, that is not what res judicata entails. The issue is not meant to be related, whatever that may mean, to issues in a previous suit. The requirement is that the issue be directly and substantially in issue. It behoved the appellant to demonstrate each of those elements in Section 7 of the Civil Procedure Act, which we have enumerated herein. It signally failed to do so. In fact, it made no effort to. We find no substance with respect in Mr. Kilonzo's submission before us that insofar as the petition that was before the High Court made several references to previous elections. It was concerned with the presidential election of 2013, and therefore all issues raised in the said petition were res judicata, as they ought to have been raised in Raila Odinga and 2 others versus IBC and 3 others. We do not think that mere reference to the past election, to that past election, brings the matter within the purview of res judicata. The requirement is that the issue raised in the later litigation should have been directly and substantially an issue in the former. They were not. It is a stretching of the facts a wee bit too far to describe the petition that was before the High Court as an attempt to relitigate the Supreme Court verdict on the 2013 presidential poll. We are quite clear in our mind that the central issue in the Raila Odinga and 2 others versus IBC and 3 others, namely the validity of the 2013 presidential poll, is not before us in this appeal. We are equally certain that the direct and substantial issue before us, namely the constitutionality of Section 39, 2, and 3 of the Elections Act, was not raised before and determined by the Supreme Court in Raila Odinga and 2 others versus IBC and 3 others. On that score alone, the plea of res judicata was for rejection. The non-commonality of issues apart, the plea of res judicata was bound to fail on the basis that the parties between the 2 sets of proceedings are not the same, or those claiming under the same parties and litigating under the same title. This is the only other aspect of the res judicata requirement that Mr. Kilonzo addressed, and we recorded him as contending that the commonality of parties is supplied by, quote, the fact that Maina Kiai, the first respondent, is a director of AFRICOG, which participated in the 2013 presidential election petition before the Supreme Court, end of quote. He went on to assert that the first respondent ought to have raised all the issues now before us in those proceedings at the Supreme Court instead of litigating by installments. With respect to Mr. Kilonzo, the reference to the first respondent herein as a party in Raila Odinga and 2 others versus IBC and 3 others is untenable. First, the first respondent is separate and distinct from AFRICOG, even were we to accept that he is the director thereof. Further and more fundamentally, AFRICOG was not a party to any of the petitions consolidated and decided by the Supreme Court in Raila Odinga and 2 others versus IBC and 3 others. One, Gladwell Gathoni Otieno, who is associated with AFRICOG, was a party in petition number 4, but mere association as a basis for mounting a res judicata challenge to a suit would be an absurd extrapolation. Given those plain facts, the res judicata objection stood absolutely no chance of succeeding, and its rejection by the High Court was inevitable. The challenge to the learned judge's sound and solid finding and holding on the same is doomed to suffer the same fate, and we dismiss it. Before we consider whether the High Court erred by declaring the impugned provisions of the Act and the regulations unconstitutional, we should address the issue of interpretation of the Constitution generally, because that declaration was premised on the interpretation of Articles 86 and 138. Interpretation of a constitution entails an inquiry into the intention of the drafters to discern the meaning of its provisions. In enunciating the fundamentals, a delicate balancing act requires to be undertaken of the textual, the contextual, the intent and purport, as well as the spirit of the Constitution. To begin with, the text is construed to establish the meaning of the words and the language, care being taken to ensure that a literal or rigid interpretation is eschewed. This should be placed in context, that is, the objectives of the enactment. The Supreme Court of India aptly considered text and context in interpretation in the case of Reserve Bank of India versus Peerless General Finance and Investment Company and others, when it stated that, quote, interpretation must depend on the text and the context. They are the basis of interpretation. One may well say, if the text is the texture, context is what gives the color. Neither can be ignored. Both are important. That interpretation is best, which makes the textual interpretation match the contextual. End of quote. In contemplating the provisions, the intent and purport of the Constitution, the objectives and aspirations, as well as the mischief to be remedied, are also brought into focus. Yet another imperative is the principle of harmonious interpretation. This was considered in the United States Supreme Court case of South Dakota versus North Carolina, when it was observed that, quote, it is an elementary rule of constitutional construction that no one provision of the Constitution is to be segregated from all the others to be considered alone, but all provisions bearing on a particular subject are to be brought into view and to be interpreted as to effectuate the general purpose of the instrument. The above outlined principles were appropriately summarized by the Constitutional Court of Uganda in Kigula and others versus the Attorney General in the following terms, which we quote. The principles applicable in the interpretation of the Constitution include the widest construction possible in its context should be given according to the ordinary meaning of the whole of the words used. The entire Constitution has to be read as an integrated whole, and no one particular provision destroying the other. All provisions bearing on a particular issue should be considered together to give effect to the purpose of the instrument. The Constitution should be given a generous and purposive interpretation to realize the full benefit of the guaranteed rights. The Constitution of Uganda, and would apply to Kenya, enjoins courts in the country to exercise judicial power in conformity with law and with the values, norms, and aspirations of the people. End of quote. See also the case of Olum and another. From this summation, it is evident that what is required is a purposive interpretation that brings into focus the principles, purposes, and peculiarities of the enactment, as well as the historical context and extrinsic materials that form an integral part of the Constitution's existence. A purposive approach was adopted in the interpretation of the Hong Kong Basic Law in the case of Ng Ka Ling and another versus the Director of Immigration. The Hong Kong Supreme Court outlined the approach thus, and we quote, "It is generally accepted that in the interpretation of a constitution, such as the Basic Law, a basic purposive approach is to be applied. The adoption of a purposive approach is necessary because the Constitution states general principles and expresses purposes without condescending to particularity and definition of terms. Gaps and ambiguities are bound to arise, and in resolving them, the courts are bound to give effect to the principles and purposes declared in and to be ascertained from the purposes declared in and to be ascertained from the Constitution and relevant extrinsic materials. So, in ascertaining the true meaning of the instrument, the courts must consider the purpose of the instrument and its relevant provisions, as well as the language of its text in the light of the context being of particular importance in the interpretation of a constitutional instrument, end of quote. Constructively speaking, a correlation can be established between the principles of interpretation under discussion and the prescriptive manner in which the Constitution in Article 259 directs that the Constitution be interpreted. It stipulates, and we quote, "This Constitution shall be interpreted in the manner that A, promotes its purposes, values, and principles. B, advances the rule of law and human rights and fundamental freedoms in the Bill of Rights. C, permits the development of the law. And D, contributes to good governance. And 3, every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking." End of quote. In adherence to these principles, the Supreme Court, in the case of Gatirao Peter Munya versus Dixon Mwenda Githinji, prescribed a purposive approach whenever the Constitution is to be interpreted. And we quote, "In Pepper versus Hart, Lord Griffiths observed that the purposive approach to legislative interpretation has evolved to resolve ambiguities in meaning. In this regard, where the literal words used in a statute create an ambiguity, the court is not to be held captive to such phraseology. Where the court is not sure of what the legislature meant, it is free to look beyond the words themselves and consider the historical context underpinning the legislation. The learned judge thus pronounced himself, and they quote him, "The object of the court in interpreting legislation is to give effect, so far as the language permits, to the intention of the legislature. If the language proves to be ambiguous, I can see no sound reason not to consult Hansard to see if there is a clear statement of the meaning that the words were intended to carry. The days have long passed when courts adopted a strict constructionist view of interpretation, which required them to adopt the literal meaning of the language. The courts now adopt a purposive approach which seeks to give effect to the true purpose of legislation and are prepared to look at such extraneous material that bears upon the background against which the legislation was enacted," end of quote, and end of quote. In conjunction with the purposive approach, the Supreme Court has also advocated for the application of a holistic interpretation as seen in the matter of the Kenya National Human Rights Commission, Supreme Court Advisory Opinion number 1 of 2012, where it stated as follows, and we quote, "But what is meant by a holistic interpretation of the Constitution? It must mean interpreting the Constitution in context. It is contextual analysis of a constitutional provision, reading it alongside and against other provisions so as to maintain a rational explication of what the Constitution must be taken to mean in light of its history, of the issues in dispute, and of the prevailing circumstances. Such scheme of interpretation does not mean an unbridled extrapolation of discrete constitutional provisions in each other so as to arrive at a desired result," end of quote. But that is not all. In pursuance of constitutional interpretation, yet another dynamic is constantly at play and requires consideration, and that is the spirit of the Constitution. The Supreme Court, in the matter of the Interim Independent Electoral Commission, cited Justice Mohammed in the Namibian case of State versus Atchison, where, in reference to the spirit of the Constitution, the judge observed that, and they quoted him, "The Constitution of a nation is not simply a statute which mechanically defines the structures of government and the relationship of government and the governed. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values bonding its people and disciplining its government. The spirit and tenor of the Constitution must, therefore, preside and permeate the process of judicial interpretation and judicial discretion." See also William Hard's title, "The Spirit of the Constitution." We dare say that in the context of the Constitution, there is an ever-present spirit that relentlessly pervades its provisions. As a consequence, that spirit, which is always speaking, must be discerned as an integral part of interpreting the provisions of the Constitution. Also envisaged as a component of the spirit are the distinct political undertones that are interwoven into the fabric of various provisions. This was appreciated by the majority of the Supreme Court in the case of the matter of the principle of gender representation in the National Assembly and the Senate, where the court at paragraph 54 asserted, and we quote that quote, "Certain provisions of the Constitution of Kenya have to be perceived in the context of such variable ground situations and of such open texture in their scope for necessary public actions." A consideration of different constitutions shows that they are often in different styles and modes of expression. Some constitutions are highly legalistic and minimalistic as regards express safeguards and public commitment. But the Kenya Constitution fuses this approach with declarations of general principles and statements of policy. Such principles of policy declarations signify a value system, an ethos, a culture, and a political environment within which the citizens aspire to conduct their affairs and to interact among themselves and with their public institutions. Where a constitution takes such a fused form in its terms, we believe a court of law ought to keep an open mind while interpreting its provisions. In such circumstances, we are inclined in favor of an interpretation that contributes to the development of both the prescribed norm and the declared principle or policy, and care should be taken not to substitute one for the other. In our opinion, the norm of the kind in question here should be interpreted in such a manner as to contribute to the enhancement and delineation of the relevant principle, while a principle should be so interpreted as to contribute to the clarification of the content and elements of the norm, end of quote. Finally, in Center for Rights, Education and Awareness and another versus John Harun Mwau and 6 others, the Honorable Mr. Justice Gidinji of this Court of Appeal, with whom we respectfully agree, outlined other important principles of interpretation of the Constitution and stated as follows, and we happily quote him. There are other important principles which apply to the construction of statutes, which, in my view, also apply to the construction of a constitution, such as presumption against absurdity, meaning that a court should avoid a construction that produces an absurd result. The presumption against unworkable or improbable result, meaning that a court should find against a construction which produces an unworkable or impracticable result. Presumption against anomalous or illogical result, meaning that a court should find against a construction that creates an anomaly or otherwise produces an irrational or illogical result, and the presumption against artificial result, meaning that a court should find against a construction that produces artificial result, and lastly, the principle that the law should serve the public interest, meaning that the court should strive to avoid adopting a construction which is in any way adverse to the public interest, economic, social, and political, or otherwise. End of quote. Ultimately, we are clear in our minds that, owing to the prescriptive requirements of Article 259 and the various pronouncements of the courts that we have adverted to, we are compelled to adopt a purposive approach when interpreting the Constitution, having regard to the intent and purpose, the historical, socio-political context, the values, aspirations, and the spirit of the Constitution. We do not agree with the appellant or with the Honorable the Attorney General that in this appeal, interpretation should be formalistic or restricted to the law, to the legal text alone, and the literal meaning of the provisions. And neither do we subscribe to the proposition that a purposive or normative interpretation is strictly limited to the Bill of Rights only. The criticism directed at the High Court in this regard is not justified. The last ground, which is the gravamen of this appeal, is the constitutionality of the impugned provisions of the Act and the regulations made thereunder. We reiterate that the court below was invited to consider whether Section 39(2) and 3 of the Act and Regulations 83(2) and 87(2)(c) are inconsistent with Article 86 and 130, Articles 86 and 138 sub Article 3 of the Constitution, and to issue the appropriate declarations. In granting the petition, the High Court found in part that there was tension between Regulation 83, Subregulation 2, and Subregulation 3. That under the latter, the decision of the constituency returning officer on the validity or otherwise of a ballot paper or a vote is final except in an election petition, while the former regulation, on the other hand, makes the results for a presidential election declared by the returning officer subject to confirmation by the appellant. Borrowing the meaning of the word confirm from Black's Law Dictionary, 9th edition, the learned judges understood the phrase subject to confirmation as used in Regulation 83, Subregulation 2, to mean that once the constituency returning officer has tallied, verified, and declared the results of a presidential election, those results would be subject to a further verification, approval, disapproval, or declaration by the appellant or its chairperson at the National Tallying Center. To that extent, they found the two sub-regulations to be in direct conflict. The learned judges found further controversy in Regulation 87(2)(c), in which it is declared that the results electronically transmitted to the appellant are only provisional. They asked the question, quote, how can the election results, which have been tallied, verified, and declared to be final under Regulation 83(3), be said to be provisional, temporary, or conditional under Regulation 87(2)(c)? They posed again, why and for what reason would a returning officer be transmitting provisional results to the commission when he has already declared the winner and issued a certificate? End of quote. In addition, they noted that since the constituency returning officer is required to retain in safe custody for a period of 3 years after the results of the elections all documents relating to the election, there can be no basis for the appellant to purport to engage in any exercise of confirming the results. Finding a parallel in the Supreme Court decision of George Mike Wanjohi versus Stephen Kariuki and 2 others, the learned judges concluded on this point that once the constituency returning officer has declared the results, those results are final and only a court of competent jurisdiction can interfere with them. In the cited case, it was noted that, and we quote, this is the Supreme Court, apart from the priority attaching to the political and constitutional scheme for the election of representatives of governance agencies, the weight of the people's franchise interest is far too substantial to permit one official or a couple of them, including the returning officer, unilaterally to undo the voter's verdict without having the matter resolved according to law by the judicial organ of the state. It is manifest to this court that an error regarding the elector's final choice, if indeed there is one, raises vital issues of justice such as can only be resolved before the courts of law, end of quote. They also made reference to Hassan Ali Joho and another versus Suleiman Said Shabal and 2 others, and reached a determination that to the extent that Section 39(2) and 3 treats results announced by the constituency returning officer as provisional, the 2 subsections are inconsistent and contrary to Article 86 and 138 sub-Article 2 of the Constitution, and therefore void, that the appellant has no power to verify or confirm the results announced by the constituency returning officer. In the end, the learned judges granted the petition by declaring that, quote, to the extent that Section 39(2) and 3 of the Elections Act provides that the results declared by the returning officer are provisional, that is contrary to Article 86 and 138 sub-Article 2 of the Constitution. To the extent that Regulation 83(2) of the Elections General Regulations 2012 provides that the results of the returning officer are subject to the confirmation by the Commission, that is contrary to Article 86 and 138(2) of the Constitution. To the extent that Regulation 87(2)(c) of the Election General Regulations 2012 provides that the results that the returning officer shall transmit electronically to the Commission are provisional, that is contrary to Article 86 and 138 sub-Article 2 of the Constitution, end of quote. The highlighted phrase subject to confirmation and the word provisional were the main cause of discomfort, prompting the first, second, and third respondents to petition the High Court for relief. It is the construction of those very words by the 3 learned judges that has now aggrieved the appellant to come to this court. As we now turn to the heart of this appeal, it is apposite for the clear appreciation of the long, windy, and sometimes turbulent journey this nation has traveled to get to where we are today, that we retrace our electoral history. Because elections determine political winners and losers, electoral processes from voter registration through to declaration of results have long been targeted for manipulation and are the foremost cause of electoral conflicts. Such manipulation, or sometimes even the mere threat of it, weakens public confidence in democratic processes, in the courts, in security agencies, in the legislature, and in the end can erode the legitimacy of governance institutions. Lack of trust among political parties and players and suspicions of electoral fraud have in the past catalyzed polarization and triggered bloody ethnic conflicts in nearly every election cycle. The reforms to electoral processes that have been initiated in Kenya have been triggered by, among other factors, failure to deliver credible and acceptable elections. Pressure from the public has been instrumental in the introduction of some of the electoral reforms that have been witnessed, as was the case in 1997 when, under the auspices of the Inter-Parties Parliamentary Group, IPPG, far-reaching constitutional changes were introduced. Global and regional obligations for transparent and accurate electoral administration have played an equally important role in setting the yardsticks by which the electoral processes and administration are to be assessed in future. But even with these many strides, the fear of manipulation of the election results and interference with the integrity of the electoral process generally persists. Nothing demonstrates this fear, mistrust, and weak processes better than the following passages from the Kriegler report. How over the years the country has done the same thing over and over again with the same obvious result, which is failure. Because of its bearing on our determination of this appeal and historical underpinning, we quote those passages in extenso. Quote, concerns about the counting, tallying, transmission, and announcement of results are not new in Kenya. In 1992, on the occasion of the first multi-party elections, an International Republican Institute pre-election report noted that, and they quoted, the electoral law does not stipulate the mechanism for transmittal of constituency results to the ECK then in Nairobi, and urges that this information be transmitted in a timely way. End of that quote within a quote. This quote continues. The report of the Commonwealth Observer Group was more drastic in its evaluation, and this is what it said. Given the poor communication between ECK and the returning officers and between returning officers and presiding officers, the lack of coordination and inconsistencies in dealing with clear-cut problems, we can only conclude that neither the polling day arrangements nor the counting processes were adequately designed or carried out to meet the specific situations and needs which the Kenyan electoral environment required. End of that quote within a quote. The situation had not much improved by the 1997 general elections. A joint report of the Institute for Education in Democracy, IED, the Catholic Justice and Peace Commission, and the National Council of Churches of Kenya recommended that, quote within a quote, it is vital to have a speedy counting exercise with results verified by all parties and announced immediately after the count is completed. This is the only way in which public confidence in the result can be ensured. Unfortunately, this was not the case in 1997. End of that quote. According to the report, the situation was no different in the year 2002. It was noted that initial results to the public were first released through the media, as ECK was not fast enough to release the results due to what was attributed to poor network in some of the polling stations. End of quote. The violence that convulsed Kenya after the disputed 2007 presidential election is a scar etched in our history and engraved in our hearts and souls forever. Regarding its causation, the Kriegler report came to the irrefutable conclusion that, and we quote, the ECK was not able to manage the counting, tallying, and results announcement processes in such a way that it secured the integrity of the electoral process at either the presidential or the parliamentary level. If one, be it a voter, a candidate, a media representative, a party leader, an election observer, cannot trust the accuracy of the election results published by an EMB, that's an electoral management body, then nothing is left, and the political system loses credibility as well as legitimacy. End of quote. Because of their relevance, we once more here below reproduce 3 of the 4 recommendations made in the Kriegler report regarding the need for integrity in the counting, tallying, and the ultimate announcement of results. Quote, IREC recommends that the ECK integrate the various descriptions of the entire counting and tallying procedure into one document and one document only, which will then be the principal description and must be adhered to. The need for such descriptive regulations does not depend on possible changes in the counting and tallying system. Next, IREC recommends that without delay, ECK start having developed an integrated and secure tallying and data transmission system, which will allow computerized data entry and tallying at constituencies, secure simultaneous transmissions of individual polling station level data to the National Tallying Center, and the integration of this results handling system in a progressive election results announcement system. And IREC recommends that ample time be allowed for verifying provisional results so that they are declared final or official only once there is no risk that errors may still be found or non-frivolous objections raised. Most countries allow 1 or 2 weeks for this. There must be sufficient time to check the provisional results, which are given status as final results only when all objections have been considered, all checks and rechecks conducted, and the final verdict issued by the proper authorities. Given a clear explanation of what a provisional result is, there is no problem in making voters understand that election results are so important that they can be declared final only once they have been properly scrutinized and checked. End of quote. Finally, on the history of elections in Kenya, and talking specifically about the last elections of 2013, the recent report of the Joint Parliamentary Select Committee on the matters relating to the IEBC, also called the Kiraito Orengo report, observed at paragraph 52. And we quote, "There were challenges experienced with the electronic transmission of the results, including that only 17,000 of the 33,000 polling stations managed to transmit results before it was overwhelmed by some technical hitches. This alternative method of getting results had to be discontinued when it became too slow, and although the problem was identified and fixed, a number of officials had abandoned the transmission as they took hard copies of the same to tallying centers. There were also network failures and suspicions of system hacking, which necessitated a reversion to physical submission of the results," end of quotes. In paragraphs 454 to 460, the report sets forth and considers the provisions of Articles 86 and 138, Section 39 of the Act, and the regulations which are the subject of this appeal. It notes that several stakeholders were concerned about the venue, manner, and process of declaration of final and conclusive elections results. There was near unanimity in opinion that since the first level of declaration of results is at the polling station, those results should be final and should only be challenged in a court of law, that the form filled out for the declaration of results at the polling station should be the primary election form, and all other forms can only be tallies of the final results rather than confirmation forms. That, for those reasons, the stakeholders recommended to the committee that Regulations 76, 77, and 78 be amended to provide for conclusive determination of ballots at polling stations and amend the relevant electoral forms to align them with this recommendation, and that further, the Elections Act be amended to provide that the results announced at the polling station be final and definite. These recommendations were informed, according to the report, by concerns based on past experience where some returning officers would annul results that had been announced at polling stations, causing uncertainty and tension in the electorate. In the committee's view, it was the mischief that informed the enactment of Article 138 Subarticle 3C of the Constitution, which requires that, quote, in a presidential election, C, after counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result, end of quote. In the end, taking into account the very many views presented, the committee recommended that the Elections Act be amended to provide for the electronic transmission of the tabulated results of election for the president from a polling station to the constituency tallying centers and ultimately to the national tallying center.
That invalidates